Brexit, the application of EU data protection law in the UK post-Brexit. Now that the UK has left the European Union in what was known as Brexit, one issue to consider is the effect on data protection both domestically and internationally. While the UK was part of the EU, the General Data Protection Regulations, GDPR in brackets, was directly applicable through the European Communities Act 1972, the ECA, along with the Data Protection Act 2018. After Brexit, legislation was enacted to repeal the ECA and incorporate the GDPR into UK law alongside the Data Protection Act. This ensured that domestic data protection framework remained largely unchanged post-Brexit, although some adjustments may be needed to replace roles previously held by EU institutions. As such, the current data protection legislation framework in the UK consists of the following. A. The UK GDPR is essentially the GDPR incorporated into UK law, adjusted to accommodate Brexit. This includes changes like replacing the European Union or member states with the United Kingdom and substituting references to supervisory authorities with the Information Commissioner's Office. B. The DPA also as amended by the exit regulations. C. Secondary legislation which may be adopted by the Secretary of State to amend the provisions of the DPA or set out additional rules, for example, payment of data protection fees. D. The codes of practice and guidance adopted by the ICO. And E. International instruments regarding personal data which the United Kingdom adheres to, namely the ECHR and Convention 108. In theory, the United Kingdom can choose to change the GDPR or other EU laws in the future. However, any changes must consider the risk of disrupting the current system that lets data move freely between UK and the EU. The European Commission wants the UK to follow international rules, especially when it comes to protecting personal data and accepting the authority of the ECTHR. If the UK government tries to change these rules, it might affect the adequacy decision.